Grant Whitmore grabbed his attorney's arm and laughed so hard his shoulders shook. He pointed directly at his wife across the courtroom and said it loud enough for everyone to hear, "She has nothing. She is nothing. This is already over." Then he leaned back in his chair, crossed his arms, and watched her walk in alone like she was already defeated. Vivian heard every single word. She didn't flinch, didn't look up, didn't stop walking. She sat down. She opened her notebook. She uncapped her pen. And in the next 9 hours, she dismantled everything Grant Whitmore had spent 19 years building without a single lawyer beside her. If you've ever been told you are nothing, stay with me. Drop your city in the comments so I can see how far this story travels. And if this is your first time here, please subscribe and follow every part to the end. You will not regret it. The morning it all began, Grant Whitmore did not look like a man who was afraid of anything. He stood in front of the mirror in his downtown Richmond penthouse, adjusting the cuffs of a suit that cost more than most people's monthly rent, and he looked at himself the way men like him always looked at themselves, satisfied, certain, completely in control. He had spent 23 years becoming the kind of man people did not argue with. Not because he was loud, not because he screamed or threatened, but because he had resources, and resources in Grant Whitmore's world were the only language that truly mattered. His company, Whitmore Holdings, stretched across 6 states along the East Coast. Logistics technology investments, real estate portfolios, distribution networks. He had built it all from a single warehouse in Northern Virginia and a relentless hunger that never quite went away, even after the money stopped being something he needed and became something he simply accumulated. He had a name that opened doors. He had connections that settled problems before they became problems. And that morning, standing in front of that mirror, he believed he had already won. He reached for his phone and called Nathaniel Cross. Nathaniel Cross was not just a divorce attorney. He was the divorce attorney in Virginia. He had represented executives, politicians, and at least 2 professional athletes whose names Grant recognized. He charged $450 an hour, and he had never once lost a case he considered important. "We're ready," Grant asked without saying good morning. "We've been ready for 3 weeks," Nathaniel answered. "Today is formality." "She still hasn't hired anyone." There was a brief pause on the other end of the line. "She filed as pro se, representing herself." Grant laughed. Not loudly, just a low, satisfied exhale that carried everything he believed about the day ahead. "Pro se," he repeated. "She has no legal background, no financial expert, no discovery team. Whatever she brings in today we can handle in our sleep." "I know," Grant said. He hung up and put the phone in his pocket. He looked at himself one more time. He had planned this moment for longer than Vivian knew. He had hired financial strategists. He had restructured accounts. He had created holding companies and funneled assets through investment groups that on paper had nothing to do with him. He had done everything a careful man does when he is preparing to leave someone behind and take everything with him. All he needed today was for the judge to see a billionaire businessman on one side of the room and a confused housewife on the other. He believed that picture would tell its own story. He believed she would collapse under pressure. He believed she would accept the settlement he offered, $300,000, a modest home in the suburbs, and a non-disclosure agreement that would bury the last 18 years of her life in legal silence. He believed she was exactly who he had spent years telling people she was. He was wrong about all of it. The Jefferson County Superior Courthouse in Virginia was an old building, the kind with high ceilings and dark wood and a weight to it that made you feel the moment you walked through its doors that whatever happened inside those walls would matter, that it would last. Grant arrived 40 minutes early with Nathaniel and a team of 3 junior associates, each carrying document boxes. A financial expert named Hargrove followed close behind a man who had testified in hundreds of proceedings and who charged separately, additionally, and enthusiastically. The courtroom filled quickly. Word had traveled the way. Word always travels in small legal communities that the Whitmore divorce was happening today. People came from other floors. Clerks stood near the back. Attorneys who had nothing to do with the case found reasons to be present, because Grant Whitmore was a name, and people wanted to see what happened when a name like that went to war. Grant settled into his seat at the plaintiff's table, loosened the button at his collar, and reviewed the day's schedule with Nathaniel, who was calm and professional, and already sorting documents in a particular order that signaled he had done this many times before. At 8:47 in the morning, the door at the back of the courtroom opened, and Vivian walked in. She wore a navy blazer over a white blouse. Her hair was pulled back cleanly. She carried a briefcase, just one, nothing elaborate, and she walked down the center aisle without looking left or right, without acknowledging the whispers that followed her steps, without giving anyone in that room anything to read in her expression. She sat at the opposing table. She placed her briefcase on the floor. She removed a single notebook and set it on the table in front of her. That was it. No associates, no boxes, no financial expert hovering behind her, no hushed conversations with a legal team about strategy. Just Vivian, a notebook, and a posture that said she had not come here to be defeated. The whispers in the courtroom rose. Grant heard them clearly. She actually came alone. She's going up against Cross without a lawyer. This is going to be over in an hour. One of the junior associates leaned toward Nathaniel Cross and said something quietly. Nathaniel looked up, studied Vivian for a moment, and then nodded with the kind of relaxed expression that said he agreed. Grant caught the exchange. He turned and looked at Vivian again. She was not looking at him. She had opened her notebook and was reviewing something calm as someone reading a menu. He almost felt sorry for her. Almost. He turned back to his team and said quietly enough that only Nathaniel heard, "Don't take too long. I have a 4 o'clock call." Nathaniel smiled. "We won't need much time." Before she became Vivian Whitmore, she was Vivian Caldwell. And Vivian Caldwell had a history that Grant Whitmore spent years making sure people forgot. She grew up in Roanoke, Virginia, the second daughter of a public school teacher and a county clerk. Her parents were not wealthy people, but they were precise people. People who believed that paying close attention to the world around you was a form of respect, and that a woman who understood the law understood something close to power itself. Vivian graduated near the top of her class at the University of Virginia. She went to Georgetown Law School on partial scholarship. She passed the Virginia bar examination on her first attempt, which fewer than half of her cohort managed. She had offers from 3 firms. She had a future that anyone who saw her at 24 years old would have predicted clearly: partner-track corporate litigation, the kind of career that doesn't happen without hunger and skill working together. She met Grant Whitmore at a charity event in Washington when she was 26. He was 33 then, already successful but not yet the name he would become, smart, attentive, generous with his words in a way that made you feel like the most important person in any room he was also standing in. He pursued her with the kind of focused attention that in those early months felt like devotion. And Vivian, who had spent years being serious and disciplined and careful, found herself pulled towards someone who laughed easily, who moved through the world without hesitation, who looked at her like she was not a thing to be assessed, but a person to be known. They were married 14 months later. She placed her law license on inactive status 8 months after the wedding. Grant had asked her to. Not demanded, not insisted. He was careful with his words in ways that took her years to fully understand. "You don't need to work," he told her. "I want to take care of you. You deserve to rest. You gave years to your career. Now let me give something back." He said it standing in the kitchen of their first home, the one in Alexandria, before the company had truly taken off, before the penthouse and the empire and the name. He said it with such quiet sincerity that Vivian did not notice until much later that the sentence had been structured to sound like generosity while functioning as removal. She stopped practicing law. She poured herself into the life Grant wanted. She learned how he liked his home organized, how he preferred to be introduced at events, how to manage the social calendar that grew more complex as his company grew. She attended dinners with investors and smiled at the right moments. She listened to conversations about acquisitions and quarterly projections and said very little. At parties, Grant would introduce her with a particular phrase that he returned to. So often it began to feel like a script. "This is Vivian, my wife. She keeps the home running. Numbers aren't really her thing." People chuckled. The polite, comfortable chuckle of people who don't need to think too hard about what was just said. Vivian smiled. She always smiled. Because she understood in the quiet place where the real Vivian Caldwell still lived that arguing in those moments would accomplish nothing. That the audience at those dinners had already decided what they thought of her based on the way Grant introduced her. That dignity sometimes meant saving your voice for the moment it would actually be heard. She kept her voice. For 19 years, she kept it. The discovery happened on a Tuesday evening in March, 8 months before the divorce proceedings began. Grant was traveling. He spent nearly 40% of his time on the road in those final years, flights to Chicago and Atlanta and Boston investor meetings, acquisition negotiations, conference presentations. When he was gone, the penthouse was quiet in a way Vivian had taught herself to appreciate. She was looking for a notary stamp, something she needed for a document related to their property in Charlottesville, a straightforward administrative task that should have taken 10 minutes. She went into Grant's private office. She didn't go in there often. It wasn't forbidden exactly. There was no lock. He'd never said don't go in there. But there was an unspoken understanding, the kind that builds up in marriages slowly, without either person ever formally agreeing to it, that the office was his space and she didn't need to be in it. She found the notary stamp in the first desk drawer she opened. She also found a folder. The folder wasn't hidden, not in any obvious way. It sat among other folders in an unlocked drawer, but the tab on this one was labeled with a set of initials she didn't recognize, not a client name, not a company name she knew. Just letters. She almost put it back. She almost told herself it was something business-related, something she wouldn't understand anyway, something that didn't concern her. But she was Vivian Caldwell, and Vivian Caldwell always paid attention. She opened the folder. The first document was a transfer agreement. A significant sum, 7 figures, moved from an account connected to Whitmore Holdings into a limited liability company she had never heard of. The signature at the bottom of the document was Grant's. The date was 11 months earlier. She stood very still for a moment. She kept reading. The second document was a property purchase record. A house in South Carolina purchased through a company whose registered address she didn't recognize for a price that represented a meaningful portion of what she understood their shared assets to be. The third document was something she hadn't expected. It was a memo from a law firm she didn't know, addressed to Grant, outlining what it described as a dissolution strategy. The memo referenced marital asset allocation, non-disclosure provisions, and what the attorney had written. She read the words 3 times to make sure she understood them. A minimized settlement approach for a spouse with no independent income, no professional standing, and no legal resources. No professional standing, no legal resources. She set the folder down on the desk. She stood in that office for a very long time. She wasn't crying. She noticed that about herself, that she wasn't crying, and it told her something. Not that she didn't feel anything. She felt everything all at once, a wave that started in her chest and moved outward. But underneath that wave there was something else, something older and steadier and harder to name. She picked up the folder again. She made a decision. She carried the folder to the kitchen table. She photographed every page. She returned the folder to exactly the position she had found it, in exactly the same drawer at exactly the same angle. She locked nothing. She moved nothing else. Then she went to the kitchen, poured herself a glass of water, and stood at the window for a long time looking at the city lights. She was already beginning to plan. What Grant Whitmore never understood about his wife was that stillness is not the same as emptiness. He saw a woman who didn't argue and concluded she had nothing to argue with. He saw a woman who smiled through difficult evenings and assumed she felt nothing difficult. He saw a woman who had stepped away from her career and decided that the career itself had never really mattered, that it had been something she was glad to leave behind, that the woman who passed the Virginia bar exam at 26 had simply dissolved into the woman who arranged dinner parties at 40. He was wrong. Because in those 19 years, Vivian had done something Grant never anticipated. She had learned his business. Not because he invited her in. Not because he shared spreadsheets or walked her through quarterly reports or sat her down and explained how Whitmore Holdings actually worked. She learned it by listening. She sat at dinners where investors talked about deals. She poured coffee at breakfast meetings that Grant held in their home. She overheard phone calls and passed through conversations and read documents left on counters and tables, not snooping, not spying, just existing in the spaces where a man builds an empire and not always thinking about who else is in the room. She had absorbed more than Grant ever imagined. She understood the basic structure of his holding companies. She recognized the names of his primary investors. She knew which accounts he treated with unusual caution and which properties he mentioned only obliquely, the way people mention things they prefer not to focus on. After that Tuesday evening in the office, she began to look more closely. Not frantically, not with the desperate energy of someone suddenly afraid. Methodically, carefully, the way she had studied for the bar exam, building a picture piece by piece from the pieces that were already available to her. She went through financial statements she had access to as a spouse. She reviewed property records that were publicly available. She used knowledge she had accumulated over 19 years to trace patterns that most people would have missed, because most people hadn't been paying the kind of attention she had. She also reopened something she had set aside for 17 years, her law license. In Virginia, an attorney who has placed their license on inactive status can apply for reinstatement. The process requires forms fees, and in Vivian's case, some continuing education credits. None of it was simple, none of it was quick, but it was possible. She filed the reinstatement application the same week she found the folder. She didn't tell Grant. She went to her small second bedroom, the one she used as a reading room, and she worked in the evenings after Grant was asleep, or traveling reviewing the materials, completing the requirements, reconnecting with 17 years of legal knowledge she had never entirely forgotten, because some things, once you truly understand them, stay with you. When Grant served her the divorce papers 6 weeks later, he held them out with a look she had seen on his face, before the look of a man presenting a solution to a problem, expecting gratitude. She took them. She looked through them. She set them on the kitchen counter. "I'll review everything carefully," she said. He frowned. It was a small frown, just a slight narrowing of the eyes, the frown of someone who received an answer they didn't know how to categorize. "Of course," he said. "Take your time." She nodded. She waited until he left the room. Then she took the papers to her reading room, closed the door, and began taking notes. The first thing Grant did after filing for divorce was freeze the accounts. This was a calculated move, and Nathaniel Cross had recommended it with the same business-like clarity he brought to everything. "Create pressure early," Nathaniel told him. "If she can't access funds, she can't afford representation. A pro se defense at this level is almost always fatal to the opposing party." Grant executed it the same afternoon the papers were served. The shared accounts were frozen. Her supplemental credit card was canceled. The automatic transfers that covered household expenses, utilities, groceries, the small maintenance costs of daily life were suspended. He expected a phone call by the next morning. He expected tears by the end of the first week. He waited. No call came. What he received instead 2 weeks later was a formal notice from the court that Vivian Whitmore would be representing herself in the proceedings, and that all future correspondence should be directed through the court's standard channels. Nathaniel reviewed the filing. "Interesting," he said in the tone of someone who finds something mildly amusing. "She's actually going through with it," Grant said. "She is, but I wouldn't worry. A self-represented party in a complex marital asset case against a full legal team is it's almost not a fair fight." Grant didn't respond. He stared at the notice for a moment. Something moved at the edge of his certainty. Not fear, not exactly, more like a slight adjustment of his confidence, the way a building might shift imperceptibly in a high wind without actually moving. He dismissed it. He told himself he was being ridiculous. She was Vivian. She arranged dinner parties and smiled at events and didn't understand numbers. He had nothing to worry about. In the months between the filing and the hearing, Vivian did not waste a single day. She moved into a small apartment in a neighborhood south of Richmond. Nothing remarkable. 1 bedroom, a kitchen, a desk where she spent most of her hours. She found work through a legal document preparation service that allowed her to bill small amounts while her full license reinstatement processed. It wasn't much money. It was enough. She sold her jewelry. Not all of it, a few pieces she kept because they belonged to her mother. But the rest, the anniversary bracelet, the necklace from their trip to Italy, 2 rings she had stopped wearing years before Grant asked for a divorce. She sold them without ceremony, converted them into months of focused time. She called a woman she had known in law school, a classmate named Deirdre Holt, who now worked in financial litigation. "I need to understand forensic accounting," Vivian said when Deirdre picked up. "I need to understand it well enough to question someone in a courtroom." There was a pause on the line. "Vivian," Deirdre said carefully, "what's happening?" "I'm representing myself in my divorce." Another pause, longer this time. "Against Grant's team. Against Grant's team." "Vivian." "I know," Vivian said. "Tell me what I need to learn." Deirdre didn't argue. She respected the tone in Vivian's voice, the tone that if you knew Vivian Caldwell from before, you recognized as the voice she used when she had already made up her mind. They spoke for 4 hours that first conversation. They spoke again the following week, and the week after. Deirdre walked her through the basic principles of asset tracing. She explained how shell companies functioned and how courts required disclosure. She described what a forensic audit looks like and what kinds of financial irregularities tend to attract judicial attention. Vivian listened the way she had always listened, completely, quietly, building the structure. She also reached out to a retired judge she had met years earlier at a civic event, a woman named Carolyn Marsh, who had spent 30 years on the bench and who, when Vivian explained the situation, agreed to a series of conversations. "You have a license," Carolyn said during their third call. "That's not nothing. That's actually significant. Most pro-SE parties don't understand the rules of evidence. You do or you did. Most of it comes back." "It's been 17 years," Vivian said. "Some things don't leave you," Carolyn said. "The ones you really understood in the first place, they stay." Vivian believed her. She studied for 16 weeks. She reconstructed this financial picture of Grant's holdings from every piece of information available to her public records documents. She had the legal right to access as a spouse, the photographs she had taken in his office, and carefully gathered evidence she had assembled using methods she reviewed twice to make sure they were entirely within legal bounds. She built a case file, not on a legal team's budget, not with a document management system and 3 junior associates, just Vivian, a desk, her old understanding of the law, and the particular patient intelligence of a woman who had spent 19 years being told she wasn't paying attention. She was paying attention. She had always been paying attention. The night before the hearing, Vivian sat at her desk in the small apartment and looked at everything she had built. Folders organized by topic, documents flagged with color-coded tabs, a legal pad with her core arguments written in handwriting that was compact and precise, the handwriting of someone who had trained themselves not to waste space. She had not told anyone, not Deirdre, not Carolyn, not her sister in Charlottesville, about the most significant piece of evidence she had found, the audio recording. It had come to her in an unexpected way, through someone she hadn't expected to hear from, a former employee of Whitmore Holdings, who had left the company 2 years earlier, on terms that had not been pleasant. The man had reached out through a carefully worded message saying only that he believed she deserved to know certain things. They had met once briefly in a coffee shop in Fredericksburg. He handed her a USB drive. He said only, "I was in the room." She listened to the recording that same evening. Grant's voice clear and unmistakable in conversation with a financial advisor, discussing the divorce, discussing the settlement strategy, discussing Vivian. The word he used for her in that recording was not wife. It was liability. He called her a liability. He said, "She has no income, no professional standing, no way to fight this. We make her appear fully dependent, offer the minimum, and she takes it because she doesn't have another option." She listened to it 3 times. She did not cry. She saved the file. She went to sleep at 10:45. She woke at 5:30. She dressed carefully. She made coffee. She stood at the window of her small apartment and watched the city come alive, and she thought about a woman who had graduated from Georgetown Law School and believed she had a future, and she thought about the years in between, all the quiet years, all the patient years, all the years of listening and watching and understanding more than anyone knew. Then she picked up her briefcase and she went to court. When Judge Eleanor Hayes called the courtroom to order that morning, she looked out at a room that was unusually full. She was an experienced judge, 21 years on the bench, the kind of experience that makes you read a courtroom's atmosphere before a single word is spoken. And what she read in that room was expectation. People had come to see something. She had reviewed the case file the night before. She knew the parties. She understood in broad strokes what this proceeding involved. What she had not anticipated was the specific image she saw when she looked at the 2 tables. Grant Whitmore on one side with Nathaniel Cross and his team arranged around him like a formation, and Vivian Whitmore on the other, alone with a notebook and a briefcase, and an expression that was, for reasons Judge Hayes couldn't immediately explain, difficult to read. She said carefully, "Mrs. Whitmore, I want to make certain I understand the situation. You intend to represent yourself today." Vivian stood. "Yes, Your Honor." "You understand that Mr. Whitmore's legal team is experienced and that the matters before this court are financially complex." "I do, Your Honor. And you've made this decision with full knowledge of your rights." "I have, Your Honor." Judge Hayes held Vivian's gaze for a moment. There was something in Vivian's eyes that she filed away without entirely knowing why. "Very well," she said. "We'll proceed." At the plaintiff's table, Nathaniel Cross leaned close to Grant's ear. 10 minutes, he murmured. 15 at most before she's in over her head. Grant didn't respond. He was watching Vivian. She had opened her notebook. She had uncapped a pen, and she was writing something calmly with the focused attention of someone who had a great deal to say and intended to say all of it. Grant watched her write, and for just one moment, one brief, small, almost imperceptible moment, something moved in his chest that he hadn't felt in a very long time. He didn't have a name for it yet, but it was the first sign, the first indication that the day he had spent months believing he had already won might not in fact belong to him at all. Because the woman sitting across from him was not confused. She was not unprepared. She was not the woman he had described at dinner parties for 19 years. She was Vivian Caldwell, and she had been waiting for this moment for a very long time. Nathaniel Cross stood up like a man who had done this 1,000 times and intended to make sure everyone in the room knew it. He buttoned his jacket. He straightened his notes. He took a single slow breath, and then he began to speak in the measured, commanding tone of someone who charged $450 an hour and believed every word that came out of his mouth was worth exactly that. "Your Honor," he said, "this case is at its core a simple one. My client Grant Whitmore built something extraordinary. He built it through sacrifice, through vision, through decades of relentless work. What stands before this court today is a man who created an empire from nothing, and a woman who for the better part of 2 decades benefited from that empire without contributing to its construction." He paused. He let that settle. How was good at pauses. He understood that silence in a courtroom could do more damage than words. Mrs. Whitmore is asking this court to award her a substantial portion of assets she did not earn, did not create, and did not build. She is asking you to reward her for the simple act of being present, and we intend to demonstrate clearly and completely that the law does not support that request. He sat down. Grant straightened slightly in his chair. That was good. That was exactly what he had paid for. Nathaniel leaned toward him and said quietly, "Your turn to watch." Grant nodded. He turned to look at Vivian. She was still writing in her notebook, head slightly down, pen moving, like she hadn't even been listening. The courtroom shifted. A few people exchanged glances. Someone in the back row whispered something to the person beside them. The ambient noise of a room full of people who expected something to happen was rising barely perceptibly like pressure building behind a closed door. Judge Hayes looked at Vivian. "Mrs. Whitmore, you may give your opening statement." Vivian set down her pen. She closed the notebook. She did not pick it up when she stood. She stood without it, both hands resting lightly on the edge of the table, and she looked at the judge, not at Grant, not at Nathaniel Cross, not at the audience that had packed the room to watch her fail, just at Judge Hayes, with an expression that was calm in the specific, deliberate way that only people who have truly made peace with a moment can be calm. "Your Honor," she said, "my husband is correct about one thing." She stopped. The room went very still. Grant's expression didn't change, but something behind his eyes sharpened. "This case is about an empire," Vivian continued. "It absolutely is. But the empire Mr. Cross just described to you, the one built on vision and sacrifice and decades of hard work, that empire has a second set of books." The air in the room changed. It was not a dramatic thing, not something you could point to and name, but everyone felt it. The shift of a moment when something that was supposed to be settled becomes suddenly unsettled. Nathaniel Cross was already reaching for his pen. "And those books," Vivian said, her voice steady as a hand that has stopped shaking because it no longer needs to tell a very different story. Grant's jaw tightened. Just slightly. Just enough. He reached over and touched Nathaniel's arm. A small touch. The kind that means something between two people who have worked together long enough to speak without words. Nathaniel nodded once and wrote something on his legal pad. Vivian was still speaking. "I want to be honest with this court about something at the outset," she said. "I am not here to destroy my husband's reputation. I am not here out of anger. I am here because I spent 19 years as part of a partnership, and I discovered 6 months ago that the other partner had been planning my exit long before he told me he was leaving." She reached into her briefcase. She placed a single document on the table in front of her. "I would like to begin," she said, "with a question about a company called Meridian Vantage LLC. The name landed in the room like a stone dropped into still water. Grant's hand, which had been resting flat on the table, curled. Just his fingers, just slightly, just enough for Nathaniel to notice. Nathaniel leaned toward him immediately. "Do you know that name?" he murmured. Grant said nothing for a moment. Then, "Handle it." Nathaniel stood. "Your Honor, the defense is introducing a company name without context, without foundation, and without establishing relevance to the marital estate. We object to this line of Mrs. Whitmore," Judge Hayes said, ignoring the objection for the moment. "Can you establish the relevance of this entity to the proceedings?" "I can, Your Honor," Vivian said. "Meridian Vantage LLC was incorporated in Delaware 14 months ago. Its registered agent is a management firm with no public-facing clients. Its sole director is listed as a man named Thomas Greer." She looked up from the document. "Thomas Greer is Grant Whitmore's college roommate. He has held no salaried position in any company for 11 years. And between the date of its incorporation and last month, Meridian Vantage LLC received transfers, totaling $4.3 million from accounts connected to Whitmore Holdings." The room did not make a sound. Nathaniel Cross was on his feet. "Your Honor, this is speculation. This is the respondent is presenting unverified documents and drawing conclusions that—" "Are these documents certified?" Judge Hayes asked, looking at Vivian. "They are, Your Honor." Vivian lifted a second set of papers and held them toward the clerk. "Bank records certified copies, corporate filing records from Delaware's public registry, and a sworn statement from a former Whitmore Holdings employee regarding the origin and authorization of these transfers." The clerk carried the documents to the judge. Judge Hayes said nothing for a long moment. She read. The courtroom waited. Grant was very still. Nathaniel sat back down. He placed his pen on the table carefully. He looked at the pen for a moment, then he looked at Grant. "Where did she get the bank records?" he said barely above a whisper. Grant's voice was flat. "I don't know." "Grant, those are certified bank records. You cannot—" "I said I don't know." In the back of the room someone coughed. The sound was startlingly loud in the silence. Judge Hayes set the documents down. "I'm going to allow this line of evidence," she said. "Mr. Cross, you will have the opportunity to respond. Mrs. Whitmore, continue." Vivian nodded. She picked up the notebook. And everyone in that room suddenly understood that the notebook was not a prop. It was not a gesture toward preparedness. It was a record organized, tabbed, cross-referenced of everything she intended to say. And she was barely through the first page. Grant looked at his wife. He looked at her, the way you look at someone when you realize for the first time that you have fundamentally misunderstood who they are. Not the polite misunderstanding of a minor assumption. The deep structural misunderstanding of a man who built his entire strategy on a foundation that had just cracked. He had believed she was unprepared. He had believed she was overwhelmed. He had believed on some essential level that the woman across from him was the woman he had described at dinner parties for 19 years. The quiet one, the domestic one, the one for whom numbers weren't really her thing. The woman across from him had just produced certified bank records and a sworn statement in the first 12 minutes of the proceeding. He reached into his jacket pocket. He found his phone. He typed a message to his business manager with one hand under the table while keeping his face perfectly composed. "Find out everything about Meridian. Today. Now." He put the phone back. He looked at Nathaniel. Nathaniel was already writing rapidly on his legal pad. Grant said nothing. There was nothing to say. Vivian was still talking. She walked the court through the transfer records with the kind of methodical clarity that made each document feel not like an isolated piece of paper, but like one more stone in a wall. She was building deliberately, without hurry, without drama, with the patient precision of someone who understood that the strongest arguments are not the loudest ones, but the most complete ones. She explained how Meridian Vantage connected to a second entity called Coastal Ridge Partners. She showed how Coastal Ridge Partners had purchased a residential property in Beaufort, South Carolina for $800,000 in cash 11 months before Grant filed for divorce. She produced the deed. She produced the wire transfer confirmation. She produced a property tax record showing the address and the ownership structure. Nathaniel objected 4 times. Judge Hayes sustained one objection on a narrow procedural point and overruled the other 3. Each overruled objection landed in the room like a small definitive click, the sound of a door being locked from the other side. Grant watched Vivian move through the documents. He watched her answer the judge's questions, and Judge Hayes had begun asking questions. Real questions, the kind a judge asks when she is genuinely engaged with what she is hearing rather than simply managing a proceeding. He watched his wife explain complex financial structures in language that was precise, but not cold technical, but not inaccessible. The language of someone who had studied enough to understand the material, but was still fundamentally a person speaking to other people. He noticed something he hadn't seen in 19 years. She was good. Not good for someone who hadn't practiced law in 17 years. Not good for a self-represented party. Good. Actually good. The kind of good that comes from intelligence working alongside preparation, and from a long patient understanding of the specific territory you are walking through. He noticed it, and something in him shifted, not toward admiration, not yet, maybe never, but toward a slow, cold recognition that he had made a serious mistake. He had underestimated her, not casually, systematically, for 19 years. Nathaniel leaned close and said very quietly, "We need to talk during the first recess." Grant did not respond. His eyes were still on Vivian. She had moved to the third section of her notebook. She was just getting started. The first recess came 90 minutes into the morning session. Judge Hayes called 15 minutes. The courtroom exhaled. People stood stretched, moved toward the back of the room. The low murmur of conversation, careful, cautious, aware that the room was still listening to itself, filled the space. Nathaniel Cross pulled Grant into a corner near the side door, away from the associates, away from the financial expert, away from anyone who didn't need to hear what he was about to say. "Tell me about Thomas Greer," Nathaniel said. "He's an old friend." "Grant. We went to school together. He does some work for me occasionally." $4.3 million in transfers to a company he directs is not occasional work. Grant pressed his lips together. "It's a private investment structure. She has certified bank records." "I'm aware. She has a sworn statement from a former employee." "I heard her." "Grant." Nathaniel's voice dropped lower, not quieter, lower in the register that serious men use when they are saying something they will not repeat. "I need to know what else she has. I need to know right now, before we go back in there, whether there is anything else in your financial structure that she could surface." Grant looked at him. He held the look for a moment longer than was comfortable. "There are some other arrangements," he said finally. Nathaniel closed his eyes for exactly 2 seconds. He opened them. "How many?" "A few." "Define a few." 3, maybe 4 structures that she might be able to trace if she has access to the kind of records she's been showing. Nathaniel Cross had practiced family law for 22 years. He had sat across from men who had hidden money in foreign accounts and women who had transferred houses to their mothers the week before filing. He had seen financial arrangements of spectacular creativity and profound legal risk. He had never in 22 years had a client use the phrase "maybe 4" in response to a direct question about hidden assets during an active divorce proceeding. He picked up his legal pad. He wrote one word on it. He turned the legal pad toward Grant. The word was everything. Grant read it. He said nothing. Nathaniel put the pad back down. "Okay," he said in a tone that had drained of warmth and become purely professional. "Here is what we are going to do for the rest of this morning. We are not going to escalate. We are not going to attack her credibility. That approach is finished, given what she just demonstrated. We are going to listen, take notes, and find the procedural gaps in her presentation. Because she is self-represented, she will make procedural errors. That is our path." Grant nodded. "And after today," Nathaniel continued, "you and I are going to sit in my office for as long as it takes, and you are going to tell me everything. Every account, every LLC, every transfer, every structure, every arrangement. Because I cannot defend what I don't know exists." Grant said fine. He said it like the word cost him something. Nathaniel straightened his jacket. "Let's go back in." They walked back to the table. Vivian was already seated. She was reviewing her notebook. She hadn't, as far as anyone could tell, moved from her chair during the recess, hadn't spoken to anyone, hadn't gone to the hallway, hadn't made a phone call. She had just sat there, reading, preparing. As they settled in at the plaintiff's table, one of the junior associates leaned toward Nathaniel and passed him a note. Nathaniel read it. He passed it to Grant. The note said, "We cannot find any public record of Meridian Vantage before she named it. She didn't get this from a public search." Grant stared at the note. He thought about his private office. He thought about the drawer he had always considered secure without ever actually locking it. He thought about the folder with the initials on the tab. I thought about a Tuesday evening in March when he had been in Chicago and his wife had been home alone, and he had not thought about that at all, because he had not needed to think about it, because the woman at home was Vivian, and Vivian didn't look at things she wasn't supposed to look at, except she had, and she had been looking apparently for much longer than just that evening. He folded the note. He put it in his jacket pocket. He looked straight ahead. Judge Hayes returned to the bench. "We'll resume," she said. "Mrs. Whitmore, you were in the middle of your presentation." "Yes, Your Honor." Vivian stood. "I'd like to turn now to Coastal Ridge Partners and a second property that was purchased through its subsidiary in November of last year." Grant heard the phrase second property and felt something cold move through him that had nothing to do with the temperature of the room. He had not told Nathaniel about the second property, not because he had forgotten, because he had believed with total confidence that no one would ever find it. He turned to Nathaniel. He said very quietly, "She found the Charleston property." Nathaniel turned to look at him with an expression that for the first time in Grant Whitmore's experience of him contained something close to alarm. "The what?" he said. Vivian was already describing it to the court. $1,100,000. A waterfront property in Charleston, South Carolina, purchased through a subsidiary of Coastal Ridge Partners, a subsidiary that existed on no document Grant had ever shared with any attorney registered under a name that was a variation of his mother's maiden name, the kind of detail that means nothing to anyone who doesn't know to look for it, and means everything to anyone who does. Vivian knew to look for it. She placed the deed on the table. She placed the transfer record beside it. She placed a photograph, a simple photograph, the kind anyone can take of the property's address number, beside the public record that connected it to the subsidiary. She did not raise her voice. She did not editorialize. She simply laid the pieces in front of the court one after another, with the steady, unhurried movement of someone who had all the time she needed and all the evidence she required. Nathaniel Cross said nothing. I was writing on his legal pad with the focused urgency of a man recalculating in real time. Grant's hands were flat on the table. He was looking at the photograph of the Charleston property. He was thinking about the 8 times he had been to that house in the past 2 years, about the drive from the airport, about the quiet street, about the way he had always believed that the physical distance between a secret and the people who might expose it was itself a form of protection. I was thinking about how wrong he had been. Judge Hayes was reviewing the documents the clerk had brought her. Her expression had changed. It was still professional, still controlled, still the expression of a judge doing a job with the rigor the job required. But there was something else now, a quality of attention that had become more deliberate, the way a person looks when they stop merely observing and begin genuinely examining. "Mr. Cross," the judge said, "I'd like your client to be prepared to respond to these asset disclosures in detail. I'm going to order a brief adjournment for lunch, and when we return, I want to understand the full picture of these entities and their relationship to the marital estate." Nathaniel stood. "Of course, Your Honor." He said it smoothly, professionally. He sat back down. He turned to Grant, and for the first time in their professional relationship, Grant Whitmore saw something in Nathaniel Cross's face that he had never expected to see there. Uncertainty, not full doubt, not panic, but the particular look of a very skilled man who has just discovered that the ground beneath his feet is different from what the map told him it would be. "I need everything," Nathaniel said in a voice so low it barely moved the air between them. "Right now, before we go to lunch, tell me every single thing she could possibly know." Grant stared at his water glass. He was thinking about the recording. He had not told Nathaniel about the recording. He had not told anyone about the recording because the recording was something that existed only in his memory and in the memory of his financial advisor, Marcus Webb, who had been in the room when the conversation happened and who Grant had believed kept it there. He was a careful man. He had built an empire by being careful. But careful men make assumptions. And the worst assumptions are the ones that feel the most reasonable at the time, the ones built not on arrogance, but on a genuine considered belief that certain things are secure because you took steps to make them secure. He had believed Marcus was loyal. He had believed the recording, if it existed at all, existed only in the room where the conversation happened. He had believed Vivian would sit across from him in that courtroom as the woman he had spent years creating, the quiet one, the domestic one, the one who didn't understand numbers. He looked at her now. She was eating a small lunch she had brought from home, something in a container, simple, ordinary, and reading from a legal reference book she had placed on the table beside her notebook. Her pen was in her hand. She was making notes in the margin of the book. She looked up. For just a moment, their eyes met across the distance between the two tables. She held his gaze, not with hostility, not with triumph, not with the heat of someone who has been waiting years for the upper hand and is finally holding it, with something quieter than all of that, with the steady, level look of a woman who had known herself all along and had been patient enough to wait until the right moment to let everyone else find out. She looked back down at her book. Grant looked away. He turned to Nathaniel. He said, "There's something else." Nathaniel put down his fork. "Tell me." And as the lunch recess moved toward its end, as the courtroom began to refill around them, and the sounds of the afternoon session gathered like weather on the horizon, Grant Whitmore sat at his table and began for the first time in this entire proceeding to be honest. Not because he wanted to be, not because honesty was comfortable or familiar or part of the strategy, but because the alternative, going back into that courtroom unprepared for whatever Vivian had left, had become suddenly and completely a risk he could no longer afford to take. He talked. Nathaniel listened. He wrote without stopping. And with each new thing, Grant named each account, each structure, each arrangement he had believed was invisible. Nathaniel's handwriting grew slightly faster, slightly tighter, the pen pressing harder into the paper, the way a person writes when they are trying to outrun a thought they don't entirely want to finish. When Grant stopped talking, Nathaniel looked at what he had written. He looked at it for a long time. Then he looked at Grant. "She doesn't know about the recording," Grant said. "She can't." Nathaniel said nothing. He just looked at him. And the silence between them was the kind of silence that answers a question more honestly than any words ever could. The afternoon session began at 1:45. Judge Hayes settled at the bench and looked out at the room with the organized calm of someone who intends to use the remaining hours productively. "Mrs. Whitmore," she said, "I believe you indicated this morning that you had additional evidence to present." "I do, Your Honor," Vivian said. She stood. She reached into her briefcase, and she removed something that was not a document. It was a small digital recorder. She placed it on the table. She looked at the judge. "Your Honor," she said, "I would like to introduce an audio recording into evidence. I have certified its authenticity through a third-party forensic audio service. I have documentation confirming the date, time, and location of the recording. And I have provided Mr. Cross with a transcript through the court's standard discovery process, which he received 4 days ago." Every person in that room heard Grant Whitmore exhale. It was not a loud sound, but in the silence that followed Vivian's words, it was the loudest thing in the room. Nathaniel Cross's hand moved to Grant's arm. Too late. The exhale had already happened. Judge Hayes had already heard it. She looked at Grant, then she looked at Vivian. "Proceed," she said. Vivian pressed play. The voice that came out of that small recorder was unmistakable to everyone who had ever met Grant Whitmore, attended one of his presentations, sat across from him at a business dinner, or watched him move through a room like a man who owned it. It was his voice, clear, confident, unhurried. And it said, "She has no income, no professional standing, no way to fight this. We make her appear fully dependent, offer the minimum, and she takes it because she doesn't have another option. She's a liability at this point. We treat her like one." The recording continued for 2 minutes and 40 seconds. Nobody moved. Nobody spoke. The courtroom sat in the particular terrible silence of people who have just heard something they cannot unhear, who have watched a version of events they had been told to accept dissolve in real time, replaced by something far simpler and far worse. A man who called his wife a liability. A man who planned in specific, calculated language to leave her with as little as possible, not because the law required it, but because he believed she had no way to stop him. When the recording ended, Vivian reached over and stopped it. She looked at the judge. She waited. Judge Hayes set down her pen. She looked at Grant Whitmore. Grant Whitmore did not look back at her. He was looking at the table. And the man who had walked into that courtroom, certain that money could solve every problem, was sitting in front of every person who had come to watch him win, with his eyes on the surface of a table and nothing left to say. Nathaniel Cross wrote something on his legal pad. He turned it toward Grant. The word on the pad was recess. Grant stared at it. He shook his head. Nathaniel turned the pad back. He wrote something else. He did not show it to anyone. He underlined it twice. Then he folded the page back and set the pen down. And for the first time in 22 years of practicing law, Nathaniel Cross, one of Virginia's most respected divorce attorneys, sat at a table in a courtroom and had absolutely nothing useful left to do, because the woman on the other side of the room had already done it all. The recording stopped playing at 2:14 in the afternoon. For 11 seconds, nobody in that courtroom made a sound. Not the clerks, not the observers packed into the back rows, not the junior associates at the plaintiff's table who had spent the morning believing they were participating in a routine asset division case. Not Nathaniel Cross, who had the professional discipline of a man trained to respond to almost anything without visible reaction, and who was now sitting completely still, with his hands flat on the table and his expression doing something it had never done in 22 years of practice, failing to be neutral. Judge Eleanor Hayes was the first person in the room to move. She picked up her pen. She wrote something on the pad in front of her, unhurried, deliberate, the kind of writing that means the person doing it has already decided something and is simply recording the decision for the record. She set the pen down. She looked at Grant Whitmore. Grant was still looking at the table. He had not moved since the recording ended. His hands were in his lap, out of sight. His jaw was set in the particular way of a man who is applying enormous internal pressure to the project of appearing composed. He was not composed. Everyone in the room could see that he was not composed, even though he was doing everything a man of his discipline could do to pretend otherwise. Judge Hayes said, "Mr. Cross." Nathaniel stood, immediately, the way you stand when you are grateful for any task that gives you something to do. Your Honor, I have a number of questions about the financial disclosures made this morning and the content of this recording. Before I ask them, I want to give you an opportunity to confer with your client. We would appreciate that, Your Honor. 10 minutes, she said. We'll recess. She stood. The room stood with her. The moment the door to her chambers closed, the courtroom erupted. Not loudly, not with the chaos of a dramatic film, but with the sudden, urgent murmur of a room full of people who have been holding their breath for 2 hours and have just been given permission to exhale. Every conversation that had been compressed into exchanged glances and raised eyebrows broke loose at once, a low tide of voices that filled the space the silence had been occupying. Nathaniel Cross turned to Grant before the judge's door had fully shut. He did not sit down. He did not lower his voice to the careful murmur he had used all morning. He spoke at the volume of a man who has stopped worrying about who hears him because the situation has moved past the point where that concern is relevant. The recording is authenticated, he said. I know. Forensic audio certification, third-party verification. She covered every procedural requirement. I know, Nathaniel. That recording describes in your voice a deliberate strategy to minimize her settlement based on manufactured financial dependency. That is not a business conversation. That is evidence of intent. Do you understand what I'm telling you? Grant looked up from the table for the first time. His eyes were steady. Whatever was happening beneath the surface of his face, the surface itself had reassembled into something close to its normal configuration. It was the particular skill of a man who had spent decades in high-stakes negotiations, the ability to look calm, even when calm was the last thing he felt. I understand exactly what you're telling me, he said. Then tell me how she got it. A pause. Marcus, Grant said. Nathaniel repeated the name without expression. Marcus Webb. He was in the room when we had that conversation. He was the only other person in the room. Your financial advisor of 11 years. Yes. Nathaniel absorbed this for a moment. He looked at the table. He looked at Grant. He pressed his lips together in the way that people do when they are choosing their words with unusual care. Did Marcus Webb have a reason to give this recording to your wife? Grant said nothing for 3 seconds. He left the company last year, he said finally. Under what circumstances? Another pause. Difficult ones, Grant said. Nathaniel nodded slowly. He picked up his legal pad. He looked at the notes he had been making since morning, pages of them now dense and cross-referenced and written with the increasing urgency of a man trying to build a wall against something moving faster than he could work. He turned to a fresh page. He wrote Webb. Then he circled it. "Okay," he said. "Here is where we are. The financial disclosures she has made this morning represent conservatively a significant underreporting of the marital estate in your initial filing. The recording demonstrates intent to deceive. Judge Hayes has seen both. She is not a judge who moves slowly when she believes a party is being deliberately obstructive." Grant said, "What are you recommending?" "I'm recommending we discuss a revised settlement position during this recess." Meaning we stop trying to win this proceeding and start trying to limit the damage. The word damage landed between them like something physical. Grant had built his entire professional life on the premise that he controlled outcomes. That preparation and resources and the right people in the right positions meant that the results of things were ultimately determinable. That chaos was a problem other men had because they hadn't planned carefully enough. He had planned carefully. He had planned for over a year. And the woman sitting 20 feet away from him in a navy blazer with a single notebook had dismantled every piece of it before lunch. He said, "What does limit the damage look like?" Nathaniel told him. Grant listened. His expression moved through several things in the span of 2 minutes. Resistance, then calculation, then something that might have been at its edges, a form of resignation. Not the clean resignation of a man who has made peace with a situation. The hard, grinding resignation of a man who is not done fighting, but has just discovered that fighting will cost him more than stopping. He said no. Nathaniel looked at him. "Not yet," Grant said. "I want to see how the afternoon goes." "Grant, I want to see how she handles cross-examination. She is self-represented. She has produced evidence, but she still has to stand up to direct questioning. She has been in control of the presentation this morning because she controlled the order. Cross-examination is different. I want to see how she handles pressure." Nathaniel studied him for a long moment. He had known Grant Whitmore for 7 years. He had seen him make decisions that looked reckless from the outside and turned out to be correct. He had seen him push situations past the point where most men would have stopped and emerged somehow with outcomes that shouldn't have been possible. He had also today seen the expression on Grant's face when the recording ended. He had seen what was underneath the composed exterior in those 11 seconds of silence. He made a judgment call. "One more session," he said. "If it goes the way I think it's going to go, we revisit the settlement conversation at the next recess." "Agreed," Grant said. "Agreed." Nathaniel turned away. Across the room, Vivian had not moved from her chair. She was reading. Her container from lunch was closed and neatly placed beside her briefcase. Her notebook was open in front of her. Her pen was in her hand. One of the observers in the back row, a young woman who appeared to be a law student based on the textbook she had been carrying when she arrived, leaned toward the person beside her and said in a voice slightly too loud for the space. She prepared the authenticated audio certification herself. The person beside her said, "Apparently." The law student said, that takes months of preparation. You have to know the chain of custody requirements, the technical standards." "She was an attorney," the other person said, "before she married him." A short silence. "He didn't know she remembered that," the law student said. The other person said, "He didn't think it mattered." Vivian, 20 feet away, turned a page in her notebook. She gave no indication she had heard any of it. But she had. She heard everything. She always had. Judge Hayes returned to the bench at 2:26. The room settled. She looked at both tables with the organized efficiency of a judge who has used her 10-minute recess to think clearly and does not intend to waste the afternoon. "We'll proceed," she said. "Mr. Cross, your client has submitted financial disclosures as part of the initial filing. In light of the evidence presented this morning, I am ordering a complete supplemental disclosure of all entities' accounts and assets in which Mr. Whitmore holds any interest, direct or indirect. This disclosure will be due to the court within 14 days. Nathaniel stood. "Your Honor, we'd request 14 days, she said. She looked at him without hostility and without flexibility. "I want to be clear about something. The evidence presented this morning describes a pattern. I am not making a finding at this moment. I am making an order. The distinction matters. Proceed." Nathaniel sat. Grant looked straight ahead. Vivian wrote something in her notebook. Mrs. Whitmore, the judge continued, you've indicated you wish to call a witness this afternoon. Yes, Your Honor. Who is your witness? Vivian looked up from her notebook. I'd like to call Marcus Webb, she said. The reaction was immediate and involuntary. Grant's chair moved just slightly, just an inch, the reflexive shift of a body reacting to something before the mind can stop it. Nathaniel's pen hit the table. Not dropped, hit. The specific sound of an object set down with more force than intended. 3 people in the observer section made audible sounds, not words, just the compressed, involuntary sounds of people who have been watching a story develop for hours and have just seen it accelerate past the point they expected. Judge Hayes said, Is Mr. Webb present? He is, Your Honor, Vivian said. He's been waiting in the hallway since 8 this morning. She said it simply, without drama, in the tone of someone reporting a straightforward logistical fact, as if Marcus Webb waiting in the hallway since 8 in the morning was the most natural thing in the world, as if she had planned it that way all along, because she had. Grant's hand found Nathaniel's arm under the edge of the table. His grip was tight. Nathaniel covered Grant's hand with his own for exactly 1 second, the professional equivalent of stay calm, and then moved it away. He stood. Your Honor, we object to this witness on the grounds of adequate notice. We received Mrs. Whitmore's witness list only 4 days ago, Vivian said, still seated, her voice carrying clearly across the room. The same day Mr. Cross received the recording transcript. Both were submitted through the court's standard discovery process on the same date. I have the filing confirmation. She held up a single page. The clerk walked over and took it. Nathaniel Cross sat down. He sat down the way a man sits when he has been outmaneuvered cleanly and knows it, and knows that everyone in the room knows it, and understands that the most dignified response is to stop standing. Grant leaned toward him. Stop her, he said. I can't, Nathaniel said. Find a way. Grant, she filed correctly. Webb is on the list. He's in the building. There is no procedural ground to stand on. A pause. I told you during the recess. Grant said nothing. Marcus Webb walked into the courtroom at 2:31. He was 62 years old, compact, with the careful posture of a man who has spent decades in professional environments and carries that precision in his body, even on days when he would rather not be anywhere near a professional environment. He wore a gray suit. He did not look at Grant as he walked down the aisle. He looked at the floor, then at the witness stand, then at Vivian briefly with an expression that carried something complex in it, guilt mixed with resolution, the look of someone who has made a difficult decision and has arrived at the moment of living with it. He sat down. He was sworn in. Vivian stood. She walked to a position that was equidistant between her table and the witness stand, and she stood there with her notebook at her side, and she looked at Marcus Webb with the same steady level attention she had given everything else in this room. Mr. Webb, she said, how long did you work for Whitmore Holdings? 11 years, he said. In what capacity? Chief Financial Advisor. I oversaw investment strategy, asset allocation, and some private financial structures. When you say private financial structures, what do you mean? Nathaniel was on his feet. Objection. Vague. I'll rephrase, Vivian said. Mr. Webb, were you aware of the existence of a company called Meridian Vantage LLC? A beat. Yes, Marcus said. How were you aware of it? I helped structure it. The room moved. Not physically, but there was a collective adjustment, the kind that happens when a room full of people all process the same information at the same moment and update their understanding of what they are witnessing. Who directed you to structure it? Vivian asked. Marcus looked at his hands for a moment. He looked up. Grant Whitmore, he said. Grant's jaw tightened. Nathaniel wrote something rapidly. Vivian moved to the next question without pausing, without allowing the weight of the answer to become something that could be disrupted or redirected. Were you aware of the purpose for which Meridian Vantage was established? Yes. What was that purpose? Another beat. Longer this time. To hold assets outside of the marital estate, Marcus said, in anticipation of a divorce proceeding. The sound that came from the observer section was not loud. It was the compressed collective sound of a room confirming what it had suspected and finding that confirmation more difficult to absorb than the suspicion had been. Nathaniel Cross objected on 3 consecutive grounds. Judge Hayes overruled all 3. Vivian continued. She walked Marcus Webb through 11 years of financial history with the systematic thoroughness of someone who has spent 4 months building a map and is now reading it aloud for an audience. She was not unkind to him. She was not punishing in her questioning. She asked directly, she listened completely, and she followed each answer with the next question that the answer required. Marcus answered everything. His voice remained steady. The steadiness of a man who has already spent considerable time with his decision and has moved past the anxiety of it into the plain, difficult territory of simply telling the truth. He confirmed the Meridian Vantage transfers. He confirmed Coastal Ridge Partners. He confirmed the Charleston property, and a fourth structure one Vivian had not named yet, one that Grant had mentioned to Nathaniel during the lunch recess, in the tight, reluctant voice of a man revealing things he had hoped to keep an account in Delaware, holding just over $2 million in what had been described internally as a deferred compensation reserve. There was no deferred compensation program at Whitmore Holdings. There had never been one. Grant was very still. He had the stillness of a man who is doing the internal arithmetic of how bad this is and who is arriving repeatedly at numbers that are worse than the previous calculation. Then Vivian asked the question everyone in the room had been waiting for without knowing they were waiting for it. "Mr. Webb," she said, "the recording that was played in this courtroom earlier today, a recording of a conversation between yourself and Mr. Whitmore, did you make that recording?" Marcus looked at her. "Yes," he said. "Why?" He didn't answer immediately. He sat with the question for a moment that stretched long enough for the room to feel it. Then he said, "Because I was in that meeting, I heard what was said, and I had met you at company events over the years." He paused. "You were always kind to the staff, always remembered names, always thanked people." Another pause shorter. "And what was being planned for you wasn't right. I knew it wasn't right. I needed time to decide if I was willing to do something about it." The silence after those words was different from any other silence the room had produced that day. It was not the silence of shock. It was not the silence of suspense. It was the silence of something true settling into a space that had been occupied for too long by something false. Vivian said, "Thank you, Mr. Webb." She turned back toward her table. Nathaniel Cross stood for cross-examination. He did what he could. He questioned Marcus on the circumstances of his departure from Whitmore Holdings. He questioned the timing of his decision to come forward. He questioned whether personal grievances had colored his recollection. Marcus answered everything. He had left the company after a dispute over the handling of certain accounts. Yes, he was aware that dispute had financial implications. Yes, he had not been happy about how it was resolved. Yes. Did that mean he had fabricated his testimony? No. Did the recording exist before his departure from the company? Yes. Did he make it because of the departure? No. He made it because he was in the room. He made it because of what was said. He would have made it regardless. Nathaniel sat down. He had not recovered anything. He had confirmed that Marcus Webb was a credible witness with direct knowledge and a documented record. Grant had not looked at Marcus once during the cross-examination. He was looking at a spot on the wall behind the witness stand, the specific, focused non-look of a man who is going somewhere inside his own head that he would prefer not to be. Judge Hayes dismissed the witness. Marcus stood. He walked back down the aisle toward the door. He did not look at Grant. He passed within 6 feet of the plaintiff's table, without acknowledgement, without hesitation, without the backward glance of someone uncertain about the choice they have made. He pushed through the door. He was gone. The courtroom breathed. Judge Hayes looked at both tables. "We'll take a 15-minute recess," she said. "When we return, I'd like to hear Mr. Cross's response to the evidence presented, and I'd like to discuss the question of supplemental discovery in more specific terms." She stood. The room stood. Nathaniel Cross turned to Grant the moment the judge's door closed. He did not use his quiet voice. He did not use the carefully modulated professional tone he had maintained all morning. He said, "We need to talk about settlement, right now, before we go back in." Grant said, "She still hasn't won." Nathaniel stared at him. "Grant, she has presented evidence. She has called a witness. The judge has not ruled. Nothing is over." "Nothing is over," Nathaniel repeated in a tone that stripped the words of the meaning Grant had intended and replaced it with something considerably darker. "You're right, nothing is over. But let me tell you what is going to happen in that room when we go back in. The judge is going to order full supplemental disclosure. Full. Every account, every LLC, every structure you named at lunch, and every one you didn't name. And when that disclosure is complete, and when it is compared to your initial filing, there will be an evidentiary record of deliberate concealment. That is not a negotiating position. That is a liability, a legal liability. Do you understand what I'm telling you? Grant was quiet. There is a version of this afternoon, Nathaniel said, where we walk out of here with an agreed settlement that is fair, documented, and final, where this ends cleanly, where you do not spend the next 18 months in litigation. That will be public, that will be examined, and that will involve every financial structure you have built being turned inside out by a court-appointed forensic accountant. He let that sit. Then he said, and there is another version, where you keep fighting, where we go back in there and I do what I can, which at this point is limited, and the judge orders everything I just described, and this case drags forward for a year and a half, and every investor, every partner, every board member you have reads about it. Grant looked at him. What kind of settlement? He said. Nathaniel told him. The number was significantly larger than what Grant had offered Vivian in the original filing. It was not the number Grant wanted. It was not the number that matched the story he had been telling himself since the moment he decided to leave the story, where the quiet housewife took what she was given and signed the paper and disappeared. But it was a number that ended this, that stopped the disclosure, that stopped the forensic audit, that stopped the next 18 months of a public proceeding that would unfold in a courthouse that was already too full of people who had too much to say about what they had seen today. Grant looked at the table. He thought about the empire, about what it had taken to build it, about the years of early mornings and late nights and decisions made under pressure and problems solved before anyone else knew they existed, about the reputation that was at this moment in a courtroom in Jefferson County being discussed by every person who had come here with nothing at stake except the story they would tell when they left. He thought about Vivian. Not the Vivian he had described at dinner parties, not the liability, not the woman with no professional standing. The woman across the room who had spent 4 months rebuilding herself from a foundation he had never known she kept, who had walked into this courtroom alone with a notebook and taken apart everything he built in a single day. He said, "Let me talk to her." Nathaniel looked at him. "Grant, not through lawyers, not through you. I want to talk to her directly." "That is not..." "It's not against the rules. We are still married. I want 5 minutes." Nathaniel considered this for a long moment. He said, "I'll ask her." He walked across the room. Vivian looked up when he approached. He said quietly, "Mr. Whitmore would like a brief conversation. Directly. 5 minutes." Vivian looked at him for a moment. She said, "Okay." Nathaniel stepped back. Grant stood. He walked across the courtroom. It was not a long distance, 20 feet, maybe 25, but it was the distance between 19 years of certainty and something he didn't have a name for yet, and it felt longer than it was. He stopped at the edge of her table. She looked up at him, not with anger, not with victory, just with attention. Grant said, "I didn't think you'd do this." "I know," she said. "I didn't think you could." She held his gaze. "I know that too." He looked at her for a moment, at the notebook, at the briefcase, at the woman who had sat across a dinner table from him for 19 years while he told people she didn't understand numbers. He said, "You've been planning this for months." "I've been preparing for months," she said. "I didn't plan any of this. You did." He had no answer for that. He said quietly, "What do you want, Vivian?" She didn't answer immediately. She looked at the notebook in front of her. Then she looked back at him. "What I want," she said, "is what I was always owed. Half of everything that was built during this marriage, because I was here for all of it, even when you made sure no one could see me." He held her gaze. He said, "And if I agree to that, then we end this today," she said, "cleanly, and we both go on." Grant was quiet. He looked at her. She looked back. Not with urgency, not with the energy of someone who needs this to go a particular way, with the settled patience of someone who has already made peace with every possible outcome and is simply waiting to see which one arrives. He said, "I'll talk to Nathaniel." She nodded. She picked up her pen. She went back to her notebook. And Grant Whitmore walked back across that courtroom, back across the 25 feet of space between the table where his wife sat and the table where his attorney was waiting, and for the first time in his memory, he had the absolute grounded certainty that the outcome of the next few hours had already been decided. Not by him, by her. By the woman who had listened when no one thought she was listening, who had learned what no one thought she was capable of learning, who had walked into a courtroom alone and made every single person in it understand without shouting, without breaking, without a moment of visible fear, that she had known exactly who she was every single day of the 19 years that he had been certain she did not. He sat down next to Nathaniel. He said 3 words. "Draft the agreement." Nathaniel looked at him. He picked up his pen. He started writing. Nathaniel Cross drafted the settlement framework in 22 minutes. He wrote it longhand first on the legal pad. He had been filling since morning using the shorthand of a man who had done this particular task hundreds of times and could produce the structure of an agreement, the way a carpenter frames a wall, not from inspiration, but from precision, from muscle memory, from the accumulated knowledge of how these things are built so they hold. When he finished the first draft, he read it back to himself once. Then he crossed out 2 lines, rewrote 1 paragraph, and slid it across the table to Grant. Grant read it. He read it twice. His expression did not change while he was reading. He had the face of a man who has been practicing composure for so long that it has become his resting state, not a mask exactly, but a habit so deep it functions like one. He set the pad down. He said, "The Charleston property." "Included," Nathaniel said. "The Delaware account." "Included." "The Meridian transfers." "Factored into the total." "Yes." Grant was quiet for a moment. He looked at the legal pad. He looked across the room at Vivian, who was at her table reviewing her own notes with the focused, unhurried energy of someone who has a great deal left to say and is simply waiting for the appropriate moment to say it. He said, "She's going to want it reviewed." "Of course she is. She'll find the gaps." Nathaniel looked at him. "There are no gaps. I wrote it to hold. If she reviews it, and she will carefully, she'll find it's complete. That's the point." "What about the non-disclosure?" There was a pause. A very particular kind of pause, the kind that exists in the space between a question being asked and the answer that the person asking already knows is coming. "She won't sign one," Nathaniel said. Grant said nothing. "You know that," Nathaniel continued. "After what happened in this room today, a non-disclosure is not a realistic term. She has standing to refuse it, and she will. And if you push for it, you are reopening the conversation about everything we've spent the last 40 minutes trying to close." Grant set the legal pad down. He pressed his fingers flat against the table, not a fist, not a slam, just the quiet pressure of a man deciding something. "Fine," he said. "Fine. No non-disclosure. Send it over." Nathaniel took the pad back. He stood, straightened his jacket, and walked toward Vivian's table with the measured steps of a man who is carrying an offer, and who understands that the manner in which it is delivered matters nearly as much as its contents. Vivian looked up when he arrived. He placed the legal pad on her table. "A proposed framework," he said. "Mr. Whitmore is prepared to discuss the terms." She looked at the pad. She read it. She read it the way she read everything completely from the beginning, without skimming, without the impatient energy of someone who wants to get to the number and skip the language. She read every line. She turned the page. She read the second page. She reached into her briefcase, removed a pen that was different from the one she had been using, red fine-tipped, and she began to annotate. Nathaniel stood at the edge of her table and watched her work. He had expected her to take time. He had not expected her to be this fast. In 6 minutes, she had marked 11 points on the document. Not arbitrary marks targeted specific. The annotations of someone who knows what language is load-bearing and what language is decorative and can tell the difference between the two at a glance. She looked up. 4 items, she said. "Go ahead." She walked him through them. The first was the valuation date for the marital assets. She wanted the date fixed to 18 months before the divorce filing, not to the filing date itself, a distinction that, depending on how the market had moved on, certain investments could represent a meaningful difference in the final number. Nathaniel listened. He did not argue. He wrote it down. The second item was the structure of the property transfers. She wanted deeds delivered within 60 days, not 90. She had seen, she said, without elaboration, what happens when timelines on property transfers are extended in contentious proceedings. Nathaniel wrote it down. The third was a provision she wanted added language specifying that if any undisclosed asset was discovered within 3 years of the agreement's execution, the agreement would be reopened and the asset would be subject to equal division plus a penalty. Nathaniel looked up from his writing. "That's not standard," he said. "No," she agreed. "But given what has been presented today, I think you'll find it's reasonable." He held her gaze for a moment. He wrote it down. The fourth item was the smallest and the most unexpected. She wanted a letter, not a legal document, not a certified statement. A letter written by Grant addressed to her, acknowledging that she had contributed to the marriage in ways that extended beyond the domestic. Not a public document, not something that would be filed or published or produced as evidence in any future proceeding. A private letter between two people who had been married for 19 years. Nathaniel stopped writing. He said, "A letter. Yes. Personal, not legal." "Correct." He looked at her for a long moment. He said, "I'll present it." He walked back. Grant looked up from the table when Nathaniel returned. "3 of the 4 are straightforward," Nathaniel said. "Valuation date, transfer timeline, penalty provision for undisclosed assets." "And the 4th, Nathaniel told him. Grant said nothing for 5 full seconds. He said, "A letter." "Yes. She wants a letter. Personal, private, not for the record." Grant looked across the room at Vivian. She was not looking at him. She had returned to her notebook. She was writing something with the red pen. He said, "What does she want it to say? That you acknowledge her contribution to the marriage, that you recognize it was not limited to domestic management." Grant was very still. Something moved across his face that did not have a clean name, not remorse exactly, not guilt in the way that word is usually meant, but something adjacent to both of them. Something in the territory of a man confronting a version of events that has always been true, but that he has for a very long time been too invested in a competing version to see clearly. He said, "That's what she wants, a letter." "Yes." He looked down at the table. He picked up Nathaniel's pen. He pulled the legal pad toward him. He began to write. Not the settlement framework, not a legal document, a letter. Nathaniel watched him for a moment. He sat back in his chair. He picked up his phone and pretended to review something on it, giving Grant the privacy that the moment required, without physically leaving the table. Grant wrote for 7 minutes. He wrote without stopping, without crossing anything out, without the labored deliberation of someone searching for words they don't naturally have access to. He wrote the way people write when they are finally saying something that has been true for a long time and has simply never been said, not easily, but without resistance, the way a weight that has been held for years feels different the moment you set it down. He folded the letter. He did not seal it. He held it for a moment. Then he set it on this table. He said to Nathaniel, "Give it to her." Nathaniel picked up the letter. He walked back across the room. He placed it on Vivian's table without a word. She looked at it. She picked it up. She read it. Nobody in the courtroom could see her expression while she read it. She was angled slightly away from the observer section, and the letter itself was between her face and the room. But the people close enough to see the back of her neck, the junior associates at the plaintiff's table, the clerk near the bench would later say that something changed in the set of her shoulders while she was reading. Something that had been held very precisely, very deliberately across an entire day of precise and deliberate holding, released slightly. Just slightly. Just enough. She folded the letter. She placed it in her briefcase. She picked up her red pen. She put a single check mark on the legal pad beside the 4th item. She slid the pad back to Nathaniel. He carried it to Grant. Grant read the check mark. He said, "We have an agreement." Nathaniel nodded. "I'll draft the formal document for execution," he said. "We'll need to present it to the judge and request a brief continuance for today," Grant said. Nathaniel looked at him. "I want to execute it today. Whatever it takes to do it today." Nathaniel studied him. "That's accelerated. The formal execution process requires, I know what it requires, make it happen today." There was something in Grant's voice that Nathaniel had not heard before. Not urgency, exactly. Not panic, but a quality of decisiveness that had nothing to do with strategy. The decisiveness of a man who wants something finished, not because he is afraid of what comes next if it isn't, but because he understands on a level that has nothing to do with law or money or reputation that the right thing is to stop. Nathaniel picked up his phone. He made a call. He spoke for 4 minutes in the quick, efficient shorthand of a man who knows the process and is compressing it as far as it will go. He hung up. "We can do a preliminary execution before the judge today," he said. "Formal certified copies within 72 hours. "Fine," Grant said. Judge Hayes returned to the bench at 3:44. She looked at both tables. She looked at the expressions on the faces of the people sitting at them. She had been a judge for 21 years. She had watched enough proceedings resolve to recognize when she walked into a room the specific quality of air that exists after two parties have found an ending. It was different from the air of a room waiting for a verdict. It was quieter, heavier in a different way. The weight of something concluded rather than the weight of something anticipated. She said, "Counselors, do we have something to report?" Nathaniel stood. "Your Honor, the parties have reached a settlement framework. We would like to request time to present the agreement to the court for preliminary approval and to proceed with initial execution today if the court is willing to accommodate that timeline." Judge Hayes looked at Vivian. "Mrs. Whitmore, do you concur?" Vivian stood. "I do, Your Honor." The judge looked at them both for a moment. She said, "All right, let's hear the terms." Nathaniel walked the court through the settlement framework. He spoke for 11 minutes. He was clear, complete, and precise. He was, whatever else the day had produced, exceptionally good at his job, and he presented the agreement with the thoroughness it required. Judge Hayes asked 6 questions. Nathaniel answered 5. The 6th, a question about the penalty provision for undisclosed assets, she directed at Vivian. "Mrs. Whitmore, this provision is somewhat unusual in its structure. Can you explain the reasoning?" Vivian said. "Your Honor, the evidence presented today demonstrates a pattern of deliberate asset concealment that predates this proceeding by at least 14 months. The penalty provision is a practical safeguard. It creates a continuing incentive for full disclosure in a situation where full disclosure was not the initial approach." Judge Hayes considered this. "I'm inclined to approve it," she said. "Mr. Cross, any objection?" Nathaniel said, "No objection, Your Honor." Grant at the table said nothing. He was looking at his hands. The preliminary approval process took 40 minutes. Judge Hayes reviewed the framework carefully, asked 2 additional clarifying questions, and noted for the record that the terms represented a significant departure from Mr. Whitmore's initial proposed settlement. A departure she described in the measured language of a judge who chooses words with surgical precision as more reflective of the applicable law. She signed the preliminary approval at 4:27. The clerk brought the framework to both tables for signature. Nathaniel signed first, then Grant. Grant picked up the pen. He held it for a moment over the line where his signature went. He looked across the room at Vivian. She was watching him, not with triumph, not with the heat of a long battle reaching its end, with something quieter than that, the specific settled attention of a woman who has waited a very long time for a very simple thing to be treated as if she existed, and who is now watching that thing arrive and finding that it looks almost exactly as she imagined it would. Grant signed. He set the pen down. The clerk carried the document to Vivian's table. Vivian picked up the pen. She read the agreement at one more time, all of it, every line. She was the only person in the room who seemed entirely unsurprised by this. The only person for whom reading the full text of a document before signing it was simply what you did, not a demonstration of anything, just thoroughness. She signed. The clerk returned the document to Judge Hayes. The judge reviewed the signatures. She said, "The court accepts the preliminary agreement. I'm scheduling a follow-up proceeding in 30 days for formal finalization. Both parties are ordered to comply with the supplemental disclosure requirements within 14 days. She looked up. "Is there anything further today?" Both tables said no. She said, "Then we're adjourned." She stood. The room stood. The gavel came down. And after 9 hours of a proceeding that had begun with a man laughing at his wife for walking into a courtroom alone, it was over. The room broke apart the way rooms do at the end of things, with the particular combination of relief and energy that comes from sustained tension suddenly released. People gathered their belongings. Conversations started. The observer section, which had sat in compressed, careful silence for most of the day, opened up into something louder and more natural. The junior associates at the plaintiff's table were packing document boxes with the quiet efficiency of people who are very professionally pretending they did not spend the afternoon watching their side of a case come apart. Nathaniel Cross packed his own briefcase with the neat, methodical movements of a man who is going to his car, then to his office, and who is going to spend considerable time this evening reviewing what happened today and what he is going to say when his colleagues ask him about it. Grant stood. He straightened his jacket. He did not gather anything because he had not brought anything that needed gathering. He stood beside the plaintiff's table for a moment, in the room that was clearing around him, and he looked at the floor and he thought. He thought about 19 years, about the version of those 19 years he had been carrying, the version where he was the builder, the visionary, the man whose drive had created everything. He thought about how complete that version had felt, how solid, how obviously true. He thought about the woman who had sat across from him all day, who had been in those same 19 years alongside him, who had moved through the same rooms and attended the same events, and listened to him describe her again and again as the quiet one, the domestic one, the one for whom numbers weren't really her thing. I thought about what it meant that she had been Vivian Caldwell all along, and he had simply chosen not to see it. Not as a deliberate act of cruelty, something quieter and more ordinary, and in some ways worse. The simple, comfortable act of a man who decided what someone was and then never updated the decision. Nathaniel touched his arm. "You ready?" Grant looked up. "Yeah," he said. They walked toward the door together. They passed within a few feet of Vivian's table. Vivian was putting the last items into her briefcase. She snapped the clasp shut. She lifted the briefcase from the table. She turned. She and Grant were face to face. No distance of a courtroom between them. No tables. No teams. No legal framework organizing the space. Just two people in a clearing room standing close enough for a real conversation. Grant stopped. He said, "Vivian." She looked at him. He opened his mouth. He closed it. He tried again. He said, "I didn't know you still." He stopped. He started differently. "I forgot who you were." She held his gaze. She said, "I know." A beat. "I never forgot," she said. That was the difference. He had nothing to say to that. Not because the words weren't true, they were, and they both knew it, but because some truths arrive at a point in time when there is no useful response to them, when the only honest thing is to stand inside them and let them be what they are. He nodded once. He walked past her toward the door. Nathaniel followed. They pushed through into the corridor. They were gone. Vivian stood at her table for a moment. She was alone in the row now. The last person at either table, the room still technically in the process of clearing, but functionally empty where she stood. She held her briefcase at her side. She looked at the room. Not at the judge's bench, not at the door Grant had gone through, not at any particular thing, just at the room, the dark wood and the high ceiling and the long windows and the particular quality of late afternoon light that fell across the floor at this hour. She had been in this room for 9 hours. When she arrived this morning, she had known what she was walking into. She had prepared for it in every specific way a person can prepare for something. She had studied the law. She had organized the evidence. She had practiced the questions. She had built the case the way you build anything that matters, slowly, carefully, from the ground up, without shortcuts. But there had been one thing she hadn't been able to prepare for. The moment when it was over. The moment when the gavel came down and the room exhaled, and the 19 years that had led to this day became officially and irrevocably the past. She had thought in the months of preparation that this moment would feel like something she could name. Victory, relief, vindication, the clean, clear feeling of a debt paid or a wrong righted. It didn't feel like any of those things. It felt like standing very still in a room where something enormous had just moved through and finding that you were still upright, that you had not been knocked over, that you were in fact exactly where you intended to be, and you had gotten there by doing exactly what you told yourself you would do. It felt like the specific, quiet satisfaction of a person who kept a promise they made to themselves. That was all. That was enough. She picked up her briefcase. She walked down the center aisle toward the door. She pushed it open. She stepped into the corridor. A few people were still in the hallway, clerks and attorney from another case. 2 observers from the room who stopped talking when she appeared and looked at her with the particular expression of people who have witnessed something and are not sure yet what it means. She walked past them. She pressed the button for the elevator. She waited. The elevator arrived. She stepped in. The doors closed. She was alone, and in the small, quiet, ordinary space of an elevator in a courthouse in Virginia. Vivian Caldwell, not Vivian Whitmore, not the quiet housewife, not the woman for whom numbers weren't really her thing, took one slow breath in and let it all the way out. She looked at her reflection in the metal of the elevator door. She looked at herself for a long moment. She said very quietly to no one but herself, "There you are." The elevator opened. She walked out. She walked through the lobby of the Jefferson County Superior Courthouse and through the front doors and out into the late afternoon, where the city was loud and alive and entirely indifferent to what had happened inside that building today, the way cities always are, the way life always is moving forward without ceremony, without pause, without any particular acknowledgement that something that mattered very much to one person has just changed permanently. She stood on the steps. She felt the air on her face. She thought about tomorrow, not about Grant, not about the settlement, not about the 14 days of supplemental disclosure or the 30-day follow-up or any of the administrative machinery that would now slowly process what had happened today into official documented permanent record. She thought about tomorrow morning, about waking up in her small apartment south of Richmond, about making coffee, about sitting at the desk where she had spent 4 months rebuilding something she had set down 17 years ago, about the decision she had been turning over in her mind for the last 3 weeks, a decision that had nothing to do with Grant, nothing to do with the settlement, nothing to do with any of this, except that it would not have been possible without it. A decision about what came next. She had been thinking about a practice, a small one, nothing elaborate, an office, a desk, a few cases, the kind of work a woman does when she has something to offer and has decided to offer it. She had been thinking about the kinds of people who walk into courtrooms, the way she had walked into one today, alone without resources, without the team that wealth provides, carrying only what they knew and what they had prepared. She had been thinking about what it would mean to be for those people, the person who helped them prepare. She had been thinking about it as an idea. Standing on the steps of the courthouse in the late afternoon light, with the settlement signed in the room behind her, and 19 years formally concluded, it stopped being an idea. It became a plan. She went down the steps. She walked toward her car. And for the first time since the Tuesday evening in March, when she had stood in her kitchen with a glass of water and the knowledge that everything she had believed about her life was different from what she had been told for the first time since that night, she did not feel the weight of what was ahead of her as something to be managed. She felt it as something to be built. She got in her car. She sat for a moment. She pulled out her phone. She opened a new note. She typed 2 words, "The office." She put the phone in her pocket. She started the car. She drove. The note on her phone said 2 words, "The office." She looked at it every morning for the first 3 days after the settlement. Not because she needed the reminder, because she needed the feeling of it, the specific grounded feeling of a decision that has moved from the territory of possibility into the territory of intent, of something that is no longer just a thought you carry, but a direction you are actually moving toward. On the 4th morning, she stopped looking at the note and started making calls. The first call was to Deirdre Holt. Deirdre picked up on the second ring. She had been expecting to hear from Vivian. She had seen enough of the courthouse proceedings through the legal community's informal channels to know that something significant had happened, though she didn't know the specifics. "Tell me," Deirdre said. Vivian told her, all of it. The morning, the evidence, Marcus Webb, the recording, the settlement, the letter. Deirdre listened without interrupting, which was unusual for her. She was a woman who moved fast and talked faster and had very little patience for narrative that didn't get to the point. But she listened to all of it, and when Vivian finished, she was quiet for a long moment. Then she said, "He wrote you a letter." "He did." "What did it say?" Vivian paused. "That he had been wrong," she said, "about what I was, about what I contributed, that he had told himself a story about our marriage that was easier for him than the true one." She paused again. "He said that the woman he introduced at dinner parties wasn't me, that he knew that he had always known it." Deirdre said nothing for a moment. Then, "Are you okay?" Vivian considered the question. "Yes," she said. "I think I am. For the first time in a while, I actually am." "Good," Deirdre said. "Then tell me about the office." Vivian told her. Deirdre listened. She asked 3 questions, Practical questions. Location funding case volume expectations in the first year. The questions of someone who is assessing a plan, not the plan itself, but the viability of the plan, the way a good friend who is also a good attorney tends to do. When Vivian finished, Deirdre said, "I know a commercial real estate attorney in Richmond who owes me a favor. She can help you find space at a reasonable rate." Deirdre. "And I have a client who ended up with a surplus legal research budget at the end of last year. I've been looking for a place to direct some of it. A new practice focused on underrepresented clients in family law proceedings seems like exactly the kind of thing it was meant for." Vivian said, "You don't have to." "I know I don't have to," Deirdre said. "I want to. There's a difference. You taught me that actually, years ago, in the library at Georgetown. You told me that the people who do the most important work aren't the ones who have to. They're the ones who decide they want to." Vivian was quiet. She said, "I said that, second year, evidence class. You were helping me understand chain of custody, and you got distracted by something and you said it. I wrote it down. I still have it." Vivian sat with that for a moment. 19 years. A version of herself she thought had become something else, still somewhere apparently, in the margins of a friend's notes from law school, still intact. She said, "Thank you, Deirdre. Don't thank me yet. Find the space first, then thank me." The second call was to Carolyn Marsh, the retired judge, who had spent 3 months walking Vivian through the procedural landscape of the proceedings. Carolyn answered the way she always answered, immediately, directly, with the no-preamble efficiency of someone who had spent decades on a bench where every second counted. "How did it go?" she said. "We settled," Vivian said. "Full disclosure complete, plus a penalty provision for anything undisclosed that surfaces within 3 years. A pause. "You got the penalty provision in," Carolyn said. "Yes." "In a single day?" "Yes." Another pause. Longer. "Vivian," Carolyn said. "Yes. I have been retired for 4 years. I have not once in those 4 years wished I was still on the bench." A beat. "Today, I wish I had been in that room." Vivian smiled. It was a real smile, the kind that doesn't come from politeness or social habit, but from something deeper and more genuine, from being seen clearly by someone you respect. She said, "I'm opening a practice." Carolyn said, "I know." "You know, I've known since March, since the first time we talked. Someone who prepares the way you prepared is not doing it just to win one case. You were building something. I could hear it in the questions you asked." A pause. "What kind of practice?" "Family law. Focused on clients who can't afford full representation, pro bono and reduced fee, self-represented party assistance." "Meaning you help people do what you did?" "Yes." "Good," Carolyn said, simply, without decoration. "I was going to ask if you'd be willing to consult occasionally, when I have procedural questions, jurisdictional nuances." "Yes," Carolyn said before the sentence was finished. "Obviously, yes. Don't ask me to be on a letterhead. I'm retired and I intend to stay that way, but call me when you need me." "I will." "And Vivian?" "Yes." "Name it something that means something, not your name, not a neutral professional name, something that means something." Vivian thought about it. She said, "I'll know it when I find it." "You will," Carolyn said. "You always do." The formal settlement finalization happened 31 days after the preliminary approval. Vivian attended with her own documentation organized complete, every page in order. She sat at the respondents' table alone as she had sat there 11 days earlier, and she reviewed the final agreement with the same thorough attention she had brought to everything in this proceeding. Nathaniel Cross was present. Grant was not. When Judge Hayes asked if either party required Grant's presence to proceed, Nathaniel said no on his client's behalf. Vivian said no on her own. The judge reviewed the agreement. She asked 4 questions. She noted once more for the record that the terms of the finalized settlement represented a substantially more equitable distribution than the initial filing had proposed. She signed the order at 10:43 in the morning. It was done. Vivian picked up the certified copy the clerk handed her. She held it for a moment, then she placed it carefully in her briefcase between 2 pieces of protective cardstock. The way you carry something that is both ordinary, a document, a piece of paper, and not ordinary at all. She walked out of the courthouse for the second and last time. She did not look back. What she did not know as she walked down those steps on a Tuesday morning in what had become a new chapter of her life was that Grant Whitmore had not attended the finalization for a specific reason. He had been on the phone, not with investors, not with his board, not with the attorneys and financial strategists who had spent the weeks since the hearing managing the fallout from the disclosure requirements. He had been on the phone with a journalist, a financial journalist who wrote for a publication that covered business leadership and who had reached out to Grant 3 weeks earlier, asking whether he would participate in a profile that in the journalist's initial framing was going to be about the challenges facing entrepreneurs in complex legal environments. Grant had agreed. He had spent 2 hours on that call. And what he had said during those 2 hours was not what anyone who had been in the courtroom 3 weeks earlier would have predicted. He did not discuss the legal environment. He did not discuss entrepreneurs. He did not frame himself as a man who had been treated unfairly by a proceeding that had gone wrong. He talked about Vivian. He talked about her with a directness and a specificity that surprised the journalist who had prepared for deflection and received instead the kind of candor that makes a good reporter sit very still and let the person on the other end of the phone keep going. Grant said, "I told people for years that my wife didn't understand business. I said it so many times I think I started to believe it. But she understood it completely. She understood it from the inside, from watching it be built, from being present for every stage of it. I excluded her from the credit deliberately, and I told myself that was because she preferred it that way. She didn't. I preferred it that way. There's a difference." The journalist asked, "What changed your understanding of that?" Grant was quiet for a moment. He said, "She walked into a courtroom by herself and took apart everything I had spent a year building. She did it alone. She did it with 19 years of attention that I had chosen to call something else." A pause. "That changes your understanding." The article was published 6 weeks later. Vivian read it at her desk, in what was by that point no longer just a plan, but an actual office, a second-floor space in a building on Broad Street in Richmond, small and clean and functional, with 2 desks and a meeting room and a window that looked out over a street she had walked down many times without ever imagining she would one day work there. She read the article once. She set it down on the desk. She sat for a moment. Then she picked up the phone. She did not call Grant. She called the woman who was scheduled to come in that afternoon for an initial consultation, a 53-year-old woman named Patricia Sowers, who had left her message 3 weeks earlier on the website. Deirdre's associate had helped Vivian build, who had written in the message that she had been married for 28 years and had just received divorce papers and had no attorney and no savings she could access because her husband had frozen the accounts. Vivian had read that message the same day it came in. She had thought about a small apartment south of Richmond, about sold jewelry, about frozen accounts and canceled cards, and the particular grinding pressure of being made to feel that, without someone else's resources, you had nothing. She thought about all of that. Then she called Patricia Sowers and told her that the consultation was free, that the meeting room was available at 2 o'clock, and that she should bring whatever documents she had and whatever questions she had, and that they would figure out where to start. Patricia Sowers arrived at 1:58. She was a small woman with careful posture and the specific compressed energy of someone holding a great deal together through willpower alone. She sat across from Vivian at the meeting room table. She put a folder on the table between them. Her hands on top of the folder were trembling very slightly. She said, "I was told this practice helps people who don't have—" She stopped. She tried again. "I can't afford a real attorney." Vivian looked at her. She said, "You're in the right place." Patricia Sowers looked at her. Something in her face, some specific combination of exhaustion and relief, and the particular fragility of a person who has been holding on alone and has just been told that they don't have to shift it. She pressed her lips together. She said, "I don't know where to start." Vivian slid the folder toward herself. She opened it. She looked at the first document. She said, "We start here." And she did. That was the first case. There were 14 more in the first 4 months, then 6 more in month 5. Then the pace picked up, the way the pace of real things picks up, when word begins to travel through the specific informal networks of people who need help and have found someone who provides it through a comment in an online forum, through a conversation at a church, through a woman who tells her cousin, who tells her friend, who tells the woman at her workplace, who has been sitting on a situation for 8 months because she couldn't see a way forward. They came. Vivian listened. She prepared. She helped them do what she had done, build cases from what they had, understand the law that applied to their situations, walk into rooms without losing the thread of who they were. Some cases settled quickly. Some didn't. Some went to full hearings, and in those hearings Vivian sat beside her clients and guided them through the process with the patient, structured attention of someone who has been in that room herself and knows from the inside what it takes to stay steady when the pressure is designed to make you break. She won more than she lost. She was honest with her clients about the difference. She told them, "I can help you be prepared. I can help you understand your rights. I cannot guarantee outcomes. The law is what it is, and courts are what they are, and some days the outcome is fair, and some days it isn't. What I can tell you is that you will not be in that room without knowing what you're doing. That much I can promise." They believed her. Because she was the kind of person whose words and whose actual behavior occupy the same space, the kind of person who says she will do something, and then does it without drama, without the need for acknowledgement, simply because it is what she said. The practice's name came to her on a Wednesday morning in the 6th week, sitting at her desk before her first client of the day, looking at the notes from the previous week's case and thinking about nothing in particular, which is always when the right things come. She thought about Carolyn Marsh's advice. Name it something that means something. She thought about a Tuesday evening in March, about a folder, about standing in a kitchen with a glass of water. She thought about a woman who graduated from Georgetown Law School and passed the bar on her first attempt and then put her license in a drawer for 17 years because someone told her she was something else now. She thought about the moment in the elevator. There you are. She opened a new document on her computer. She typed Caldwell Legal Advocacy. She looked at it. She added a tagline beneath it. She typed, "For those who are still there." She looked at that. She did not change a word. She sent it to the designer Deirdre had connected her with, and it became the name on the door, the name on the website, the name that within 8 months the Virginia Legal Aid Society had in their referral database. The name that within 14 months, a reporter from a Richmond legal journal had written a 1,200-word piece about describing Vivian Caldwell, not Vivian Whitmore. Vivian Caldwell, which was the name she had placed on all her professional materials, from the first day, the name she had always had, the name that had always been hers, as one of the most effective family law advocates working with underrepresented clients in Central Virginia. She read that article the way she had read everything since March, completely without skimming, building a full picture before drawing a conclusion. Then she set it on the desk beside the first article, the one Grant had participated in. She looked at both of them for a moment. 2 articles, 2 versions of the same story written from outside it, trying to understand what had happened in a courtroom in Jefferson County on a day that had been 11 hours long and 19 years in the making. Neither of them got it entirely right. That was fine. That was how it worked. The people inside a story always know things that the people writing about it from the outside cannot fully reach. What Vivian knew that neither article captured was this. The day in that courtroom had not been her victory. It had been her retrieval. She had not won something new. She had recovered something old, something that had always been there waiting behind 19 years of polite smiles and dinner party introductions, and the patient accumulated weight of being told in 100 small and large ways that she was not the person she had always known herself to be. She had gone into that courtroom and gotten herself back. Everything that had come after the settlement, the practice, the clients, the name on the door, was simply what happened when you operated from your actual self instead of the one that had been constructed for you. That was not a mystery. That was not a miracle. That was just what was possible when a person stopped accepting someone else's definition of their limits and started working from their own. It was a Tuesday afternoon 14 months after the courthouse when Vivian's phone rang with a number she recognized. She looked at it for a moment. She answered. Grant's voice on the other end was different from the voice she had heard in that courtroom. Not softer exactly, more careful. The voice of a man who has spent a year living with what he knows about himself now and is still in the process of deciding what to do with it. He said, "I read about your practice." She said, "I know, the journal piece." "And the legal aid referral, a colleague mentioned it." "Small world," she said. He said, "Vivian," and then stopped. She waited. He said, "I wanted to tell you that what you built the practice, what you're doing, I think it matters. I know it's not my place to say that. I know you don't need me to say it. I just wanted to." She held the phone. She thought about 19 years, about a kitchen, about a folder in a drawer, about an elevator at 4:27 in the afternoon. She said, "Grant, yes, I know you mean that, and I appreciate it." A pause. "But you're right about one thing. I don't need you to say it." He said, "I know." A silence that was not hostile, not warm exactly. The specific silence of two people who shared a very long chapter of a life and are now in different chapters and are finding slowly what remains between them when the legal structure and the conflict and the 19 years of accumulated weight are finally set aside. He said, "How are you?" She thought about it genuinely. She said, "I'm good, Grant. I'm actually good." He said, "I'm glad." She believed him. She said goodbye. She hung up. She put the phone down on her desk. She looked at it for a moment. Then she picked up the file for her 2 o'clock client, a 47-year-old woman named Sandra Howell, who had called 6 weeks ago from a gas station parking lot because she had been afraid to make the call from home, who had whispered her situation into the phone like someone confessing something who had said at the end of the call, "I don't think I have a case, and I don't think I have any options." Vivian had said, "Come in, let me hear everything, and then we'll see." Sandra was coming in at 2. Vivian opened the file. She read through her notes from their previous meeting. She reviewed the documents Sandra had brought. She thought about the specific legal questions the case raised and the specific approach she intended to take. She thought about a woman who had walked into a courtroom with a notebook and walked out with her life. She thought about all the women who didn't know yet that they could do the same. She closed the file. She looked at the name on her door visible through the glass panel from her desk, Caldwell Legal Advocacy, for those who are still there. The door to the office opened. Sandra Howell walked in. She was early, 3 minutes early. The kind of early that says this appointment mattered enough to leave before it was strictly necessary to arrive, before you were completely ready to be here, before you had fully decided how to begin. She stood in the doorway for a moment. She looked at Vivian. Vivian stood. She said, "Come in, Sandra. Have a seat." Sandra Howell sat down. She put her folder on the table. Her hands were trembling, just slightly. The trembling of a woman who is holding a great deal together and has come to a place where she is hoping, not yet believing, but hoping that she doesn't have to hold it all alone anymore. Vivian sat across from her. She looked at Sandra Howell, the way she looked at everything completely without hurry, with the full attention of a person who has learned at considerable cost and over considerable time that paying close attention to the world around you is not just a habit, it is a form of power. She said, "Tell me everything." And Sandra Howell took a breath, and she began to speak. And Vivian listened, the way she had always listened, the way she would always listen. Because this was who Vivian Caldwell was, not a woman who had been discovered in a courtroom, not a woman who had surprised the world with what she knew, not a woman defined by what she had endured or what she had survived or what had been taken from her and returned. She was a woman who had known herself every single day of the 19 years that someone else believed she did not, and who had finally, in one long, clear, extraordinary day, made sure that the rest of the world knew it too. And now she sat across from women who were where she had been, and she gave them the only thing that had mattered in the end. Not money, not connections, not a powerful team, or a stack of documents, or the kind of access that wealth provides. She gave them the truth of what they already were, and she helped them find their voices. And when they finally stood up to speak, the room always listened.